Welcome to the top 10 church legal issues for 2025. We are live from the Carpenter Law Firm studios, my office with a green screen. My name is Scott Carpenter. I'm one of the attorneys at the Carpenter Law Firm. We're going to go through kind of the top 10 legal issues that we confront here at the Carpenter Law Firm for our church clients throughout Arizona. The content is specific to November 21st, 2024. If you're watching this seminar from our website after November 21st, 2024, we're not making any guarantees that the information is accurate after November 21st, but it is accurate today, November 21st, 2024, accurate in terms of our observations about the legal issues that we're dealing with in Arizona as of November 21st, 2024. All right, so what's the legal environment? Well, the legal environment is that it appears to be getting more and more challenging every year. Here at the Carpenter Law Firm, the lawyers here, we've been working with churches and nonprofits and tax-exempt organizations for nearly 30 years. And every year something happens, something comes up, but the legal environment has become more challenging every year. And I'm going to kind of hit 10 areas that seem to be more challenging every year as we go. All right. So we're going to do this Dave Letterman style. We're going to count down from 10 to 1 in a rough order of what we really need to be focusing on and kind of how we approach things here at the law firm. Number 10 is employment law issues. Now, one could make the argument that this should be number 1, number 2, or number 3, but I list it here at number 10. What are the employment law issues? Well, really, we have this somewhat misunderstood ministerial exception to what you could call the normal employment law requirements. When you walk into Circle K or QT and you encounter an employee, let's say QT, and that QT employee who always has a smile and is always very well trained in the QT expectations and always says something at the end like, "See you next time," which is obviously well trained, or a Chick-fil-A employee, highly trained and very well versed in their expectations. Well, we call these normal employment expectations. Well, just because someone is well trained doesn't mean that the employer is meeting all employment law requirements, minimum wage and overtime, things like that. Well, that employee may be well trained, but that employee may, and I'm making no comment about Chick-fil-A or QT, but that doesn't mean that the employer is meeting minimum wage and overtime requirements. So that's what I'm talking about here when I talk about normal employment law requirements. Anti-discrimination, you can't discriminate in employment based on someone's protected status, gender, race, national origin, things like that. You can't discriminate because someone's Canadian, because they're Hispanic, because of their country of origin, all of those things. Normal employment law requirements, things that not everyone knows, but that are a sort of bedrock to employment law in America and Arizona. Well, the ministerial exception says that a church can discriminate in the hiring and firing of ministers. We'll put that in air quotes. Ministers are an exception to normal employment law requirements, whether it's minimum wage, overtime, or discrimination, whether it's gender, national origin, or any of those anti-discrimination legal requirements, wage, wage an hour, overtime, things like that. So the ministerial exception is an important piece of the employment law landscape for churches. Well, only ministers fit within the exception. So we deal with this somewhat routinely, and I did a seminar earlier in our series of the 2024 series of seminars. You can find it on my website, carpenter.law, where we talked about whether a church could simply say that the landscaping employees are ministers of campus impressions. Can we simply label every employee as a minister of something? The receptionist is the minister of first impressions. No, we can't do that. The US Supreme Court created the ministerial exception. And there are certain requirements for the ministerial exception. If you're not a minister, then everyone else on the church payroll can bring a discrimination claim or any other employment law protection claim, workers' comp, wage and hour, overtime, minimum wage, anything like that. So what is a minister? Well, the Supreme Court, when they said in their opinions what a minister is, said before they introduced the test, said, we're not going to adopt a rigid formula. Well, we lawyers like rigid formulas. We like, here's the formula, 1, 2, 3, 4. But in saying we don't adopt a rigid formula, they adopted, or they made an observation about a particular litigant that displayed 4 characteristics. I'm going to tell you what it was. Is the person held out as a minister and given a formal ministerial title? Youth pastor, pastor to adults, children's pastor. That's a ministerial title. Does the church hold this person out as a minister? Is the person on the website as the children's pastor? That's an example. Has the person undergone a significant degree of religious training in order to obtain the title? And one of the things that's happened, of course, in recent years is that formal seminary training is not as common as perhaps it once was. Someone can go to church and say, well, there's an opening to be the children's pastor. I have been volunteering with children for 5 years. I know the ropes. I know what's going on. The children's pastor just resigned to move across the country. I'm going to apply. And now I'm the children's pastor. That person did not undergo a significant degree of religious training in order to obtain the title. It's more of a job description. It's more of a spot on the org chart than a ministerial observation or a ministerial role based on significant degree of religious training. The person has a job of children's pastor without seminary or Bible college training. Is the person held out as a minister? On the website, is there an org chart that's distributed or in the office somewhere where it says children's pastor? Now, I'm using the word pastor. We can't let that confuse us. It doesn't make any difference. A minister is sort of the legal term that the US Supreme Court used, but pastor and minister, of course, are the same thing. And then finally, has the person performed significant religious functions, including a role in conveying the church's message and carrying out its mission? Well, in my example, has this person taught on Sunday morning? Do they lead the children's ministry? Do they get up in front of the children during the summer vacation Bible school week and teach the large group? Do they train the volunteers? That's a significant role in conveying the church's message and carrying out its mission. So it's not that difficult to conclude that someone is a minister if they're actually doing the church's work in carrying out the function of the ministry. But it would be very, very difficult, it would be difficult uh, to shoehorn someone into these four questions if they're simply maintaining the landscaping. And there's nothing wrong with maintaining the landscaping. But that person, or answering the phones, or having a part-time job, 20 hours a week, coming in and doing a mailing, a USPS mailing, or folding the bulletins for Sunday, that is not a ministry. You're simply an employee. We are not going to stretch someone into a ministerial function when that's not what's actually happening. So it's important that we don't get too excited about the ministerial exception. It's there for pastors and ministers, clergy, but it's not there to exempt regular employees. In a law firm, it would be the equivalent of there are lawyers and there are support staff. Lawyers went to law school and passed the bar exam, and the receptionist and the file clerk are not lawyers. You can't make them lawyers by calling them lawyers. They did not go to law school. They have no legal training. We don't hold them out as lawyers. It's not, we, we can't invent someone we can't turn someone into a lawyer. Same thing would be true in a medical office. You're either a doctor or you're not. And we can't turn someone into a doctor by saying, well, you put people on the scale, you weigh them, you ask them questions and put information in the computer. When you put them in the exam room, you take their temperature. Doctors can do that too, but that doesn't make you a doctor because you take their temperature and put them on a scale and give them a shot every once in a while. That's not the same thing. So employment law issues come up from time to time. And then not just the ministerial exception, which is a categorization. Sometimes people do make claims and we have to deal with them in the normal way that all employers deal with claims across the country. An overtime claim, a claim at the Department of Labor for discrimination, a claim for overtime, a workers' comp claim. These things come up routinely, and we have to deal with them as lawyers the way any employment law claim would be dealt with. And there's also the opportunity to obtain insurance called EPLI, Employment Practices Liability Insurance, which is a species of insurance that all churches should have because there is exposure for all of your employees that are not ministers. And that EPLI insurance is a valuable type of insurance that can respond to claims by any employee who makes an employment-related claim that might come against the church that's not exempted by the ministerial exception. And it might also respond even if something is exempted by the ministerial exception. Now, EPLI insurance often pays legal fees to defend, but it may not actually, in the end, indemnify. If you lose the case, the insurance might not pay the judgment against the church. But sometimes the most valuable type of insurance is insurance that pays the legal fees through the dispute process, through the litigation process, because that's where the real expense is. All right, let's go to number 9. My colleagues here at the Carpenter Law Firm and I have been seeing more real property issues. This is related to the land that the church sits on. And real property issues have to do with improvements, such as street and infrastructure improvements for churches that own their own property, where cities, municipalities, and counties have come along and said, well, we have aging infrastructure. The sewer line needs to be redone. We need an easement, and we need to negotiate an easement with the church. We're seeing that more recently. And we also are seeing more activity with eminent domain. This is where the government takes property, has to pay for it, of course. And so we've got more cases lately where we're negotiating with the government for eminent domain easements and other issues related to government interaction with church property. And then, of course, as we always have for churches, and not just recently, property leases where churches are leasing their campuses from other property owners, whether it's leasing their campus from a school, a shopping center, or churches sharing their own campuses with charter schools or other private schools. And those lease provisions can be more complicated than we think. We've negotiated leases that were 50 pages long. And you say, well, that's overkill. Why can't it just be 3 pages? Why can't we just shake hands and say, well, we're going to lease these 3 buildings. You'll use it during the week and we'll have our church on the weekends. Well, we can do that. But then when we start talking about, well, what about this and what about that? And what if there's a problem? We've got to deal with that. When it works well, and it often works well, and there's no problem, it should be able to be done in 2 or 3 pages. But these agreements, as we can all appreciate, they're really in the spirit of a prenuptial agreement. It's what do we do when it all goes wrong? It's not about the monthly rent, but it is about that, of course. But it's what are we paying for monthly rent? That these agreements are really pre-negotiating what's going to happen when we have problems. And it's up to the lawyer to figure out how to make sure my client is protected. 99 times out of 100, my client is the church. How do we make sure the church is protected when it's the tenant? And how is my client, the church, going to be adequately protected when it's the landlord? So we wear different hats, different perspectives, but of course, good lawyers, it doesn't matter which it is. Today I'm the landlord, tomorrow I'm the tenant. Negotiating to make sure that the church is protected in every scenario. Doesn't have to be complicated if there's a good trusting relationship, but the lawyer's paid to think of the worst case scenario and protect the client in that situation. So we're seeing more of this, but it's not necessarily more complicated than it's always been. But we need to be aware that the churches need to be protected with its real property issues. All right, let's go to number 8, real estate transactions. Churches are still buying and selling property. There's a lot of different reasons for this. You might think, well, interest rates are high. Well, sometimes churches have property to sell and they're cash rich. And so they're out purchasing. Every once in a while, this happens, whether it's here in Arizona or somewhere else in the country. There's a good bit of transactional work happening across the country. There's also, and I'll talk about this at another numbered topic. There's also churches that have declining congregation populations that need to sell property, which creates a buying opportunity for other churches. We also negotiate letters of intent, and I have the word "why" in parentheses. As a real estate lawyer, which I don't know what kind of lawyer I am. Am I a church lawyer? Am I a real estate lawyer? Well, all of the above, I suppose, at times. But a letter of intent is a transactional document that says we intend to make an offer along the following lines, and then there are deal points included. But at the end of a letter of intent, it almost always says this is non-binding, and we may not send you a purchase and sale agreement for you to sign. And the reason I have the word why in parentheses is because it's a letter of intent, an intention to make a binding offer that the seller can accept or not. And I find it to be a somewhat frustrating part of real estate transactional work because at the end it always says it's non-binding. And I talked to a real estate broker recently who does a good bit of church land transactional work. And I said, these letters of intent are really frustrating because they're always non binding. And he said, well, Scott, I get it. They are frustrating. We spend a lot of time and energy pre negotiating deal points with the other side. Buyers and sellers actually negotiate letters of intent. Why do we do that? If at the end of the letter, it's signed by both sides and it says it's non-binding. What's up with the exercise? Perhaps you can appreciate that from a lawyer's perspective, this seems like a complete waste of time. Well, his explanation was we're pre-negotiating deal points so that we don't have to worry about it later. When we get to drafting the 50-page purchase and sale agreement, the document that ends up at the title company to actually complete the transaction for the purchase and sale of the property. Okay, fine, I get it. Just getting some of the hard negotiating out of the way early. So we've got purchasing and selling property by a church as the seller, owner, by the church as the buyer, and negotiating the LOI. And then once we're done with that, we have to negotiate a purchase and sale agreement. Well, I have a client that just recently asked me to look over a purchase and sale agreement prepared by the seller. And my task was to compare it to the LOI and make sure that it was in line with the already negotiated terms. Well, I did. And the lawyer for the seller inserted multiple new provisions into the purchase and sale agreement that were not in the LOI. And I identified them and I didn't like any of them. Well, okay, but see, the reason that's okay in a sense from the seller's perspective is because the letter of intent was non-binding. So the lawyer who drafted the purchase and sale agreement felt free to insert new provisions that were onerous for the buyer, my client, and better for the seller because the letter of intent was non-binding. So just put together a purchase and sale agreement that integrated the letter of intent provisions, but then inserted multiple new provisions. And if they were more friendly to the seller, so be it. It doesn't really make any difference. So sticky provisions, new ideas about limitations of liability, and other things that were not in the letter of intent. So that's number 8. We're still doing a lot of deals despite interest rates, cash deals. Some churches, the big ones are out doing deals. Multi-site churches are out doing deals. Nothing wrong with that, but the way our economy works, the big companies keep getting bigger, and growth creates growth, and big churches keep getting bigger, and there's still deals being done. All right, number 7, let's talk about premises liability. This is liability created by the physical premises of the church. And it doesn't matter if you own the church or if you're renting the church, when you invite people to your place, it has to be safe. Now, if we were in Chicago or Buffalo, New York, we would be talking about icy sidewalks, and we have a term for that. It's called the slip and fall, where someone slips and breaks their hip because we have an unsafe premises. We're inviting people onto the property. So the question we ask is the campus safe? When we invite people onto the premises or the campus, is it safe? We worry about sidewalks. We do worry about shoveling snow in the winter in Arizona, of course. We're not too Maricopa County centric about this. Carpenter law firm operates throughout the whole state. We are worried about everything being safe. We worry about playground equipment. We're concerned about the bathroom floors during Sunday morning. Is there a routine inspection? Is someone assigned to inspect the places on your campus that could get wet and become slippery during the high volume traffic times? I have had opportunity over the years to be involved, not personally, but involved somewhat tangentially as a mediator in some personal injury cases. And as it turns out, grocery stores are so concerned about their stores being wet for slip and fall cases that there's an assigned person who walks around the entire store on a routine basis and keeps a log of how often they go up and down each floor, including the produce section, where it's most likely to have a water event, or by the refrigerated section where someone could uh, grab a gallon of milk and drop it or something like that. And they're required to keep a log of when they were there and how often they've inspected each aisle of the grocery store. And they do this so that if someone slips and falls in the grocery store, they can go to their log and say, well, Bob was on duty at 7:30 and inspected aisle 15 at 7:27, and there was nothing there. He did a cleanup at 7:15 because there was something there, and you claim you fell at 7:40 or whatever. And so they have the log. But this should be happening at the church as well, even if you're meeting in a public school. While the church is leasing the public school and you're inviting the public onto the public school property, we need to have a protocol that the bathrooms are being inspected in case the eighth grade boys go in there and decide that they should be filling up a bucket of water and throwing it on the floor, so that when my dad goes in there, 82 years old, and just had back surgery and uses a walker, and now all of a sudden he's got a broken hip, that we've got a significant personal injury lawsuit that we're dealing with. Now, hopefully our insurance is great and my dad's claim is covered by insurance, but this is a problem. And it makes no difference whether you own the facility or not. You're inviting members of the public into your service. It's a public school bathroom. Is somebody inspecting it routinely? Who's assigned to that? Is it a volunteer? Is it a paid staff person? We're concerned about premises liability. Are the sidewalks on your church campus, have they been raised up a half an inch by tree roots? I mean, all of these things matter. And you might say, well, that's why we have insurance. Well, that's kind of just not the right attitude. We've got to be concerned about people and whether they're going to be injured on our campus. Who's doing traffic control in the parking lots? Is your parking lot dangerous during Sunday morning? Is the landscaping trimmed in a way that the sight lines are safe? Is there something about the way traffic moves on Sunday morning or Saturday afternoon or Saturday evening, whenever your services are, that's negligent or unsafe? We worry about that also. If somebody's going to come onto the campus and get in a car accident or a car collision and blame the church for it, for having no traffic control, whether it's cones or an actual person directing traffic. It's one of the reasons why security and traffic control is a big issue for a number of churches, not just to get everybody parked and into the service, but for liability concerns as well. there are claims for negligent traffic control of parking areas. We're concerned about that. All right, let's go to number 6. We've had a couple of things come up already that point to insurance. Churches, every church should recognize that you're operating with two different types of risks: risks you keep and risks that you shift. You shift risks through the payment of a premium. Every business does this, every household does this. There are risks that you keep and risks you shift. You always keep the risk from zero to the coverage amount. We call that the deductible, and you're keeping the risks above the policy limit. One of the things that's happened in my career when I started practicing law in the early 90s is that even back then, people would say, well, we'll just get $1 million of coverage. Well, it sounds like a lot of money because we'd all agree that $1 million is a lot of money. But really, for a lot of businesses and a lot of people, they have maintained this $1 million limit because it seems like a lot of money. But is the $1 million calibrated to what a jury would do in a particular claim scenario? My dad's 82. He slips and falls on a wet bathroom floor. What's a jury going to do with that case? When my dad calls one of these personal injury lawyers on the billboards and they take the case to trial and the jury decides the church is negligent for what it did, left the water on the floor, didn't have anybody inspecting, whatever the issue is a jury going to say $1 million is the total exposure? Is $1 million of insurance enough to cover what a jury would do, or should the church carry more than $1 million? And I don't know what you're carrying at a particular church, but this idea that $1 million of general liability insurance is enough is, I think, becoming pretty outdated. So we keep certain risks that are below the we keep every risk below the deductible, and we keep every risk above the policy limit. So we're only shifting what's covered. And what I suggest here is that all churches should undertake a realistic assessment of what are our risks of operations. Employment risks, EPLI, employment practices, liability insurance, workers' comp, and general liability, specialized insurances that churches can take advantage of. There's a lot of them. But what ends up happening in most churches is that the consultants that churches use, and I know a bunch of church insurance brokers, and they're all, the ones I know are great, but it's an abstract question. The consultants that churches generally use for the assessment are the brokers. And there's an argument, and I say this objectively, sort of a law school whiteboard point here is those selling the insurance, there's an argument to be made that they are really not the right consultants to do a realistic assessment of a church's risk profile, because they have a financial stake in selling the risk shifting product. And so when we are doing the assessment of the risk of operation, that the consultant that says, well, there's a risk of operations X, Y, and Z, and oh, by the way, we have a product that will help you shift that risk. You could see the cynicism of that. So I'm not really saying that they shouldn't be trusted, but in most cases, the consultants that churches rely on are the people that sell the risk shifting product. And oh, by the way, many businesses do exactly the same thing. Small business operating, renting widgets to other businesses, when they go about the same exercise of what risks to keep and what risks to shift, the consultants are the insurance brokers that sell insurance to businesses that rent widgets. So you're not unique in this profile of getting the consulting on which risks to shift and which risks to keep from the brokers who sell the risk shifting insurance. And like I said, I know the brokers, and they're high quality brokers and high quality people. But objectively, I wouldn't be a good lawyer if I didn't point out uh, that there's room for some cynicism about that, simply diagramming it on a whiteboard. All right, let's talk about church dissolutions. We're seeing more of this where uh, congregations are shrinking, and a dissolution might be facilitated by a denomination or other overseeing body. Every once in a while, a congregation will shrink to the point where they will recognize on their own we need to dissolve and figure out what to do with the campus, and on their own just decide to do something. Now, a couple of things to remember: this creates a land divestiture task after corporate dissolution. By land divestiture task, I mean the land has to be conveyed somewhere, has to be conveyed, not sold necessarily. It has to be conveyed. The corporate dissolution may require a vote to the congregation or the board, but by the point of inevitability, the vote is usually not the legal challenge we're dealing with. When the congregation has shrunk to that point, we're usually not dealing with, oh my goodness, how do we get the vote? If we're down to 10 people, we're not worried about how are we going to get a vote of 1,000 people. By the time we're talking about dissolution, we're down to 10, 20 people. But here's where we sometimes have a challenge. We have a shrinking congregation, and I say congregation because we're talking about the portion of the church. And when I say the church, I mean the church in the sense that we're all part of the body of Christ. We're all part of the church, and so we're talking about a particular group of believers that are congregating in that building. So the corporate dissolution of this congregation, on dissolution, according to the IRS statute, the Internal Revenue Code statute, for a tax exempt organization, for this congregation, on dissolution, all real property must be conveyed to another 501c3 organization. That's a statutory requirement under federal law. So that's where we come in with what could be a bit of a challenge. So, First Church of Anytown, Arizona is shrinking. If there's a denomination or other overseeing body, that denomination could receive ownership of shrinking congregation at First Church of Anytown, Arizona. And we've satisfied this IRS rule because the denomination or other overseeing body might hopefully be 501c3 exempt. No problem. But if it's a congregation that's shrinking on its own, then we have to find a suitable recipient of the church property that is also 501c3 exempt. And so that's the issue with dissolution. All right, let's talk about merger. We are seeing more and more merger activity because that's the alternative to dissolution. Rather than dissolving and conveying the property, let's merge with another church. Preferable for obvious reasons. There are bigger congregations looking for additional meeting space, obviously, different parts of town that would gladly take on the burden of maintaining the property. But I have seen in doing this type of legal work that mergers are challenging in trying to blend congregation cultures. This is really the number one challenge. Now, of course, as a lawyer, I can accomplish the corporate merger. I can help accomplish the real estate transaction that's part of the corporate merger. We can do the corporate merger from a corporate standpoint. We can accomplish the real estate transaction that's part of the merger. But blending congregational cultures is a pastoral and lay leadership challenge that a lawyer can't really help with. But I've seen it be a challenge for a number of my clients. And other than being hopeful and prayerful about it, the lawyer can't really help much. But we're seeing more of this activity. And whenever I have a client that comes in to talk about a dissolution, I do say, have you thought about a merger? We can try to find a merger partner, uh, perhaps a little easier than we could, um, do to find a dissolution partner. As I've mentioned, there's the last bullet point here on the screen. A dissolution partner is simply someone to receive the property. Um, Perhaps a merger partner would be a better thought, or at least another thought, perhaps not better. The church congregation is dissolving either way. A merger partner is at least another idea. As I mentioned, the legal issues are not overly complex. Um, Merger can be a little more can be somewhat expensive from a legal fee standpoint. Sometimes the lawyer has to take some time for what I call hand holding, which is explaining the legal process. In a merger, a lawyer can only have one client, but there are two entities. There's two law firms often involved in a merger that doubles the legal expense, but eventually there's going to be one entity. So we call that meeting with the client, explaining. Um, Lawyers tend to bill hourly, so we call that hand holding. That may be an insult. I don't mean it to be. All right, let's talk about number three. IRS audits of political activity. We just had an intense period of election in America. Every 4 years we do this, of course, and um, political activity by tax exempt churches is prohibited by law. And last month I did a seminar on IRS policies, and I talked a good for churches, and I talked a good bit about this requirement that churches not engage in political activity. In 2025, we may see audits of churches for engaging in political activity. It's also possible we will not see an audit, any audits of churches for engaging in political activity. There's really no way of knowing for certain if the IRS bureaucracy will move in this direction. As you know, there is some who view the federal bureaucracy of sort of acting on its own, having its own frame of mind. And if that's true, then we would see the sort of independent hive mind of the DC federal bureaucracy moving toward these audits, irrespective of who won the election and irrespective of whether they perceive that the winning presidential candidate would want it or not. And irrespective of whether the churches being audited were in favor of the winning presidential candidate or not. If you believe that the hive mind of the federal bureaucracy does whatever it wants to. And so we don't know one way or the other. Um, so we're not sure, but it could happen. And churches that did preach preference for one political candidate over the other, particularly in the presidential election, were violating federal law by doing so. There's no question about that. So any pastor that got up at the pulpit and said, you should vote for presidential candidate number one, or said you should vote for presidential candidate number two, that did violate federal law. All right, let's talk about number two, childcare and teenagers. And I've put teenagers and put the word camp in parentheses. So childcare challenges are not unique to 2024 or 2025. As we move along, we've always had childcare challenges, and we're going to continue to see them. Let's just say hiring volunteers is difficult. Now, that sentence makes no sense. We don't hire volunteers, they're unpaid. We recruit volunteers, but let's just admit that whether we hire volunteers or recruit volunteers, it's difficult. One of the reasons why volunteers do not want to spend time on training. Their basic attitude is, I'll show up, point me in the right direction, and then I'm out of here. If the service is at 9, I'll show up at 8:57, and then at 10:30, I'm going to bolt, and I may not even stay long enough for the person who's relieving me for the 10:30 service. And if you say, we need you here Wednesday night at 6:30 for volunteer training, you may not get an RSVP. They're not going to say no. They're not going to say yes. They may not even come. And if you try to entice them with a meal, it won't make any difference. That's my experience with this. It's very, it's still, it's difficult. Okay. So volunteers is difficult. In some cases, volunteers know a little too much about childcare issues. They've received intense public school training. They teach in public schools. They administrate public schools, and that's a good thing. But they know a lot about the duty to report, and they're experts in child development. They're experts in children and childcare, and that can be challenging for churches, especially for the person charged with leading the child care efforts for the church. They can't know too much. I shouldn't have put it that way, but they become a challenge because they're second guessing or want to control how the church goes about its child programming. But we still have obligations to keep the children safe. That's number one, and to have good programming as well. So that's part of the challenge here. And then when we get to number one, you'll see it come into full color with the duty to report. A little sneak peek at the number one. Teenagers, camp is challenging. Camp has always been challenging. And one of the things about camp that's challenging is 30 years after camp, people can remember camp was terrible. I was abused at camp. The counselors were bad. I was sexually assaulted at camp, and now I remember it. And I'm not saying it didn't happen, but this is what has happened in a number of camp scenarios. And now I'm going to file a lawsuit against the church and the camp and all the counselors and everybody who was involved. So camp is challenging. And because of all the issues and all the challenges with camp, a valid question could be raised. Should we even be doing camp? Now, one thing about teenagers that we could say, should we even be doing it, is something from my teenage years, the old overnight lock-in in the gymnasium. Nothing good ever came from the overnight lock-in at the gymnasium. Uh, People pairing off, discovering, wow, girls are interesting. I like this girl. I'd like to find a dark spot under the bleachers and spend as much time with her as possible between 3 and 4 a.m. And bad things happen at lock-ins, and depending on the facility and how many dark corners there are, it's almost impossible for the leaders to monitor everything going on. And when bad things happen, or when normal things the boys and girls seek to want to do with each other happen, the parents get upset, and the parents get upset with the church and the leaders that their kids were allowed to explore during the lock-in. Do kids fight during lock-ins? Of course they do. Are they upset about that? Yes. I mean, the lock-ins are bad, but camp is challenging. How do you vet counselors? What's your process? Is it simply a criminal background check? I don't like criminal background checks because there are some statistics that show, like, for example, that when it comes to a convicted sex offender, the average sex offender offends 30 times before their first conviction. Well, that's a pretty scary statistic as far as I'm concerned, that a convicted sex offender, which results in a registered sex offender, might have 30 victims under his belt before the first conviction. It's a terribly disturbing statistic. Now, why did I say he? Well, it's the men that the registered sex offenders, basically, statistically speaking. So by the times they would show up in a criminal background check, there's 30 victims before that first conviction. So how do we vet counselors? Well, I guess that's all we can do is criminal background check, but you can see how it's flawed. We're just checking whether someone's been caught and convicted as to whether they're going to be a counselor, but it's flawed, clearly. So we've got to vet counselors, do the best we can, but no lawyer is going to say that's sufficient because it's full of holes. And I just mentioned the one. What are we doing for medical care at camp? I mean, we're taking possession of these kids for a whole week, sometimes longer. How are we plugging holes for what happens when someone has an asthma attack, or they fall and hit their head? What's our evacuation plan? How do we ensure that someone could get to a hospital as quickly as possible? And by the way, when was your camp release document last updated? What are we doing for medical care release and for liability release? What do these documents look like? And when was it last refreshed and last reviewed? These are important questions. The law is evolving, and whenever we take teenagers to camp, we have to be sure that we've got everything updated. And when it comes to counselors, what kind of statement are they agreeing to before they go to camp? What kind of avowals are they making? I hereby avow and swear that I'm going to abide by the following behavioral restrictions while at camp. I'm not going to have my phone. I'm not going to look at porn while I'm at camp. Stuff like that. I mean, we've got to be strict with our counselors too. We have to have a set of behavioral restrictions on our counselors while they're at camp. They bring in their laptops. You know, what are they doing while they're at camp? Or some of them are going to say, "This is ridiculous. I was never going to do that anyway." Maybe they'll be insulted, but no, the counselors have to agree to behavioral restrictions while they're at camp too. I mean, phones are dangerous. Laptops can be dangerous too. What kind of images and videos are stored on these devices that the kids could bump into. All right, finally, number 10, in reverse order, we've gotten to number 1, legal issues for 2025, the duty to report. Arizona has a somewhat complex duty to report abuse for children. And this kind of fits with number 2, child care and teens. Here's what it says. Any person, but this is not really any person. Person is a specifically defined finite set of people, which I'll get to in a second. So don't don't get hung up on this could be anybody in the universe, but it's a certain finite set of people who reasonably believes that a minor is or has been the victim of physical injury, abuse, child abuse, a reportable offense, or neglect that appears to have been inflicted on the minor by other than accidental means, has to report it. Now, what's a reportable offense? A reportable offense is there are 20 of them. Think of it as being exposed to pornography, child sex trafficking, anything bad, everything bad, but mostly physical injury, abuse, child abuse, rape, sexual exploitation, everything from neglect, a parent abusing them, a cigarette being put out on their forearm, everything and everything in between. The first thing I want to point out here is that this person who has a duty to report has to have a reasonable belief that the minor has been a victim of one of these bad things. What does a reasonable belief mean? It means you have to actually believe it. All right, who is a person under the statute? The statute has a definition. It's a member of the clergy, priest, or Christian Science practitioner. Can't get too hung up on the word clergy. It's a pastor. It's a pastor or someone in a similar position at the church. The parent, step parent, or guardian of the minor, and then everybody at the school. School personnel, domestic violence victim advocate, or sexual assault victim advocate who develop the reasonable belief in the course of their employment. And then this one, which is tricky at churches, any other person who has responsibility for the care or treatment of the minor. Now, this is where the school people who volunteer on Sunday mornings say, I have a duty to report. But why do they say that? It's because they're trained at school on the third bullet point. They receive this duty to report training all the time because they're school personnel. But they did not obtain this reasonable belief in the course of their employment. They obtained it in their off time while volunteering at church. But under the fourth bullet point, they would say, during the hour I'm here on Sunday morning, I have responsibility for the care or treatment of the minor. So the teacher who's working on Sunday morning from 9 to 10 does have a reasonable belief because they've observed the kid with bruises, the burns, the whatever. And so they feel like they have to call 911. But not for the third bullet point reason, which is their training. I'm a teacher, I have a duty to report. But for number 4, because for that hour, they had responsibility for the care of the minor. So what some churches do, and I could spend an hour on this one. I have done seminars before where I spend the whole hour on the duty to report. And I don't want to do that. I'm committed to these seminars being 59 minutes, and I'm right there. Any person who has care or responsibility for the treatment of the minor, if they have that reasonable belief, the church cannot say to this teacher / volunteer, report it to the church and we'll deal with it. Under the statute, the person who has responsibility for the care or treatment of the minor has to call 911 or CPS. Whichever, whatever you want to call it. Now, here's the other twist. If you're a member of the clergy and you receive a confession, and that's how you find out about it. Guy comes into your office and says, I've been touching my daughter, and that's the only way you know about it. You don't have to report it. Now, that has nothing to do with the teacher or Sunday morning volunteers. That's still a bullet point number 3 and a bullet point number 4 problem under the definition of person. Just for pastors and clergy, there's a confession exception. Now, this is where I find that my church clients call me a good bit. I call it the someone said problem. The pastor calls me up and says, well, 22-year-old is dating a 17-year-old and they're having sex. And I say to the pastor, how do you know that? Well, the mom called me and told me. The mom of who? The mom of the daughter. So I call this the someone said problem. Go back to the very first bullet point. Can that pastor reasonably believe that that woman, that 17-year-old woman, daughter, girl, whatever you want to call it, is the victim of what we call in Arizona statutory rape? Now, under Arizona law, she is the victim of statutory rape. She's 17, the boy is 22. That's statutory rape. That's a reportable offense. Can the pastor be deemed under the law to have a duty to report under the someone said scenario? Only he can decide whether he has a reasonable belief that she is a victim of statutory rape because mom says she's having sex with her 22-year-old boyfriend and is therefore a victim of statutory rape. Now, in order for the pastor to be convicted of the crime of failure to report under the duty to report statute, the prosecutor has to convince a jury that he had a reasonable belief and did not report it. Now, you can probably appreciate that's going to be a pretty high bar for the prosecutor to come over to convince a jury that in a criminal sense, the pastor didn't report it, but had a reasonable belief that it had happened based on the someone said scenario. So when I deal with these issues and pastors call me and say, well, here's what we know. And I say, what do you know? How do you know that? And then it turns into, when I drill down a little bit, not in a rude way, because that's not how I am, the belief comes from, as I said earlier, the someone said scenario. We don't have any doubt that the statutory rape occurred or is occurring. The underage girl, the overage boy. But how does the pastor know it is happening? Well, he's not in the room. He hasn't seen it. It's not a confession, although it could be a confession from the 22-year-old. But that's an exception. It's the someone said scenario. Now, the pastor might say, that's enough for me. I know the woman who's the mother of the victim. I believe it. She wouldn't react this way if it weren't true. The daughter wouldn't say it was happening if it weren't true. So I reasonably believe it's happening, so I'm going to report it. Now, good and responsible pastors say, we're going to report it and let law enforcement figure it out. And that's the reasonable thing to do. So that's where we are moving forward. I believe the duty to report is one of the number one issues moving forward, because as a society and a species, um, we can't seem to rid ourselves of this abuse that seems to be happening. And in particular, we're not getting along very well in our households. Children are still victims. They're being abused. Sexual crimes and problems are still happening in our houses and in our culture. And the duty to report statute is an attempt to uh, wedge law enforcement into these situations sooner rather than later. Is it working? I don't know. Perhaps, perhaps not. But the law enforcement folks, the detectives and police that end up getting involved in these situations, have zero tolerance for churches that do not report. Zero tolerance. So if there's something that you see on a Sunday morning, if the protocol is report it to the church and we'll deal with it, that's not going to work. I've had plenty of clients where the internal protocol is to the volunteers, tell us about it and we'll deal with it. The detectives and the child protective services, that's the wrong answer from their standpoint. All right, questions? We use the chat feature for this in the webinar format. I went a little over, I apologize for that. If not, that concludes the top 10 for 2025. Thank you for joining me, and look forward to continuing our seminar series in 2025. I have one more in December where we'll do a preview of legislation and other legal issues for 2025. Thank you for joining me.